By the contract of agency, a person binds himself to render some service or to do something in representation of another. You are transferring your legal capability to someone else, allowing them to sign contracts, move assets, and alter your legal universe on your behalf. The Civil Code contains the risks of this transfer within a strict statutory quarantine zone. To understand exactly how the law contains this risk, we have to map the physical boundaries of that quarantine zone. We do that by sequentially deconstructing Articles 1877 through 1883 of the new Civil Code. We are going to isolate the semantic walls that separate administrative acts from strict dominion, the specific bar exam mnemonics you need to memorize, and the exact traps examiners use to fail candidates. Mastering these statutory perimeters is the difference between passing the bar examination and assuming total personal liability. Article 1877 establishes an ironclad rule of interpretation. The law does not trust broad, sweeping language in agency contracts. An agency couched in general terms comprises strictly and only acts of administration. There are 0 exceptions to this rule. Even if the principal includes clauses stating he withholds no power, or that the agent may execute such acts as he may consider appropriate, the authority remains locked inside administrative bounds. For the bar exam, the baseline is simple. Under a general power of attorney, an agent can pay ordinary debts, hire workers, or buy office supplies to keep a business running. They cannot sell the actual business. This is the unlimited management trap. Examinees see a contract loaded with dramatic, empowering language and assume the agent can do anything. Never equate a heavily worded general mandate with the legal authority to execute acts of strict dominion. Acts of strict dominion are actions that encumber or dispose of the principal's wealth. To execute any of these, the agent must hold a special power of attorney, or SPA. Article 1878 lists 15 specific cases requiring an SPA. To categorize the highly tested requirements, we use the mnemonic CLAIMPIGS. C is for compromise, or submitting questions to arbitration. L is for the lease of real property to another person for more than 1 year. A stands for acquiring or conveying immovables. I is for accepting or repudiating an inheritance. M restricts mortgaging or loaning money. P groups together making payments outside normal administration and entering into partnerships. Finally, the remaining I, G, and S cover innovations, specifically novation, making gifts, acting as a guarantor, and any other act of strict dominion. The law allows rare exceptions within these gates. An agent can make customary gifts to charity or employees without an SPA, and they can borrow money if it is urgent and indispensable for the preservation of the administered property. The most frequent bar exam trap here targets leases. An SPA is only required if the lease meets 2 specific conditions. It must be for real property, and it must exceed 1 year. A 2-year lease on a car does not require an SPA. Note that Article 1878 dictates the nature of the authorization required. It requires clear and unmistakable language granting the specific power. It does not simply mandate a notarized form labeled SPA. Failing to identify the need for an SPA for any of these 15 acts is a mistake in issue spotting. Without it, the agent's act of strict dominion is legally unenforceable against the principal. Article 1879 establishes that special powers are strictly construed and mutually exclusive. A special power to sell categorically excludes the power to mortgage, and a special power to mortgage does not include the power to sell. Examiners test a logical fallacy that the greater power of selling implies the lesser power of encumbering with a mortgage. The Civil Code rejects this entirely. Beware the business necessity trap. A question will present an agent authorized to sell who cannot find a buyer, so they mortgage the property to save the business from immediate bankruptcy. Under the strict text of 1879, that mortgage is void as to the principal. Article 1880 applies this same isolation to dispute resolution. A special power to compromise does not authorize submission to arbitration. The rationale is control. A compromise keeps ultimate approval with the principal. Arbitration legally surrenders jurisdiction and decision-making power to a third-party tribunal. In agency law, related powers are never implied. They operate in absolute, legally isolated silos. Article 1881 defines the physical perimeter of an agent's execution power. The agent must act within the scope of their authority. They are implicitly authorized to perform peripheral acts, provided those acts are strictly conducive to accomplishing the main purpose of the agency. It is vital to differentiate between exceeding legal authority and merely violating a principal's secret instructions. If the agent acts within the written power of attorney shown to a third party, the principal is bound, despite breaking a private arrangement. But Article 1882 introduces the concept of the advantageous breach. The limits of authority are not considered exceeded if the execution is demonstrably more advantageous to the principal than specified. This does not override absolute negative prohibitions. If a principal strictly forbids selling above a certain tax bracket ceiling, breaking it is a violation, regardless of the extra gross profit. If an agent is authorized to sell a car for $500,000 in cash and they secure $600,000 in cash, the transaction is perfectly valid. The principal is bound. Here is the qualitative trap. An agent cannot alter the nature of the transaction. If authorized to sell for $500,000 cash and the agent exchanges the car for a plot of land appraised at $1 million, the agent has exceeded their authority. A sale cannot become a barter. The Civil Code will forgive and absorb financial overperformance, but it will ruthlessly void any attempt to change the mandate's actual nature. Article 1883 establishes what happens when an agent acts entirely in their own name. Doing so snaps the tether to the principal. The principal has no right of action against the third party, and the third party has no action against the principal. The agent becomes directly and personally bound, exactly as if the transaction were their own. However, there is a singular, highly tested vulnerability that pierces this veil: the property exception. If the underlying contract involves things belonging to the principal, the veil of privacy is instantly destroyed. The legal consequence is immediate. The principal and the third party now have a direct right of action against one another, completely bypassing the agent's signature. For the bar exam, the moment a hypothetical features an undisclosed principal, you must immediately audit the ownership of the subject matter. If it belongs to the principal, Article 1883 bridges the gap. In the eyes of the Civil Code, the true ownership of the asset always overrides the signature on the bottom line. Agency is a rigid, unforgiving statutory framework designed to isolate liability and control the transfer of legal power. General words establish the administrative boundaries of 1877, while acts of strict dominion require the specific authorizations of 1878. These powers remain mutually exclusive under 1879 and 1880. Selling is never mortgaging, and compromising is never arbitrating. Execution must stay within the perimeter of 1881, unless financially advantageous under 1882. And the agent's personal veil under 1883 falls the second the principal's property is involved. Mastering this strict textual perimeter secures your understanding of legal risk. It is the definitive tool for dominating Title X on the bar examination.